Good morning, I'm Gary DeWaal, and this is Bridging the Week for February 5th to 9th, and today is February 12th, 2018. Last week, the chairman of the Commodity Futures Trading Commission and the Securities and Exchange Commission provided their insight into the risks of cryptocurrency activities before a Senate committee. During his testimony, J. Christopher Giancarlo, CFTC chairman, suggested it might be appropriate to extend federal oversight to spot virtual currencies and exchanges to avoid gaps in current regulation. Additionally, the first trader convicted of spoofing under a Dodd-Frank amendment to existing law expressly designed to prohibit such activity appealed his conviction to the United States Supreme Court, claiming the law change was unconstitutionally vague. The 23rd Winter Olympics in Korea officially began last week in freezing temperatures and a potential thaw in relations between North and South Korea. So I can hurry up to my couch to watch the games and keep warm with the heater on and a steaming cup of joe, let's get started. J. Christopher Giancarlo, chairman of the Commodity Futures Trading Commission, posited that additional federal regulation may be appropriate to eliminate quote-unquote gaps in the current oversight of spot transactions in virtual currencies and trading platforms during an appearance before the Senate Banking Committee last week. Mr. Giancarlo appeared before the committee jointly with Jay Clayton, chairman of the Securities and Exchange Commission. Mr. Giancarlo stated that, quote, appropriate federal oversight, end of quote, could include data reporting and capital requirements, cybersecurity standards, measures to prevent fraud and price manipulation, as well as anti-money laundering and know your customer protections. He said that, quote, a rationalized federal framework, end of quote, may be preferable to the current quilt of state-by-state money transmitter regulations. Mr. Clayton, during his testimony, observed that previously, both Mr. Giancarlo and he had noted their openness to consider, quote, whether increased federal regulation of cryptocurrency trading platforms is necessary or appropriate. Although Mr. Giancarlo indicated that the CFTC's regulatory approach of quote-unquote do no harm is the right approach in connection with distributed ledger technology, virtual currencies likely require, quote, more attentive regulatory oversight, end of quote, because of the involvement of retail investors. During his testimony, Mr. Clayton cautioned, quote, Main Street investors, end of quote, to be cautious when investing in cryptocurrencies of any type, particularly those issued as part of initial coin offerings that should be registered as securities and are not, or are not lawfully exempt. Like Mr. Giancarlo, Mr. Clayton questioned whether, quote, our historic approach to the regulation of sovereign currency transaction is appropriate for these new markets, end of quote, in virtual currencies. As I indicated in this blog last week, it may be appropriate to give the CFTC jurisdiction over the purchase and sale of cryptocurrencies in interstate commerce to the extent such instruments are not securities. However, this jurisdiction should be exclusive so as to avoid overlap and inconsistency in approach with multiple state regulators. I have more of my views on the article version of this vlog at bridgingtheweek.com. Check it out. Michael Kosher, the first individual convicted of spoofing under an amendment to applicable law adopted as part of the Dodd-Frank Wall Street Reform and Consumer Protection Act in 2010, requested the U.S. Supreme Court to overturn his conviction. Mr. Kosher claimed that the amendment, which prohibits any trading, practice, or conduct on a Commodity Futures Trading Commission regulated trading facility that, quote, is of the character of, or is commonly known to the trade as spoofing, i.e., bidding or offering with the intent to cancel the bid or offer before execution, is unconstitutionally vague. Mr. Kosher, who was also convicted of engaging in commodities fraud, additionally argued that intent alone cannot transform bona fide trading activity into fraud. In 2015, after a 7-day trial in a federal court in Chicago, Mr. Kosher was convicted of commodities fraud and spoofing in connection with his trading activities on CME Group exchanges and ICE Futures Europe from August to October 2011. Mr. Kosher had initially been indicted for such offenses in October 2014. Previously, in July 2013, Mr. Kosher settled civil actions related to the same conduct underlying his criminal indictment with the CFTC, the UK Financial Conduct Authority, and CME Group Exchanges by payments of aggregate fines of approximately $3.1 million US, disgorgement of profits, and a 1-year trading suspension. According to his indictment, during the relevant time, Mr. Kosher utilized 2 computer-driven algorithmic trading programs that repeatedly placed small buy or sell orders in a market, followed by the rapid placement and retraction of large orders, so-called quote orders, on the opposite side of his small orders. He supposedly did this in order to deceive the market and help ensure the execution of his small orders at favorable prices. After the initial small orders were executed, Mr. Kosher would reverse the process, placing new small orders on the opposite side of the markets as his initial filled orders and large quote orders on the opposite side of the new small orders. He allegedly traded this way in order to ensure the fills of the new small orders and profits on the overall transaction. As I have previously written, the Dodd-Frank anti-spoofing provision is badly drafted because it uses a term that is assumed to be commonly understood and is followed by a parenthetical that is too broad in scope. The provision fails to reference the totality of the transaction that is problematic, namely the placement of an order with the intent to cancel it prior to its execution to induce the non-bona fide execution of an opposite side of the market order. I also have more on this on the article version of my vlog at bridgingtheweek.com. Check it out. And finally, the New York State Department of Financial Services imposed new requirements on all licensed New York virtual currency businesses to help avoid fraud and market manipulation. Licensed persons will include businesses possessing a so-called New York BIT license or certain limited purpose trust companies authorized to conduct a virtual currency business. Specifically, such businesses, including those additionally licensed as money transmitters in the state, must put in place measures, quote, to effectively detect, prevent, and respond to fraud, attempted fraud, and similar wrongdoing, end of quote, including manipulation. According to the New York State Department of Financial Services, quote, market manipulation is a form of wrongdoing about which virtual currency entities must be especially vigilant, given that such manipulation presents serious risk both to consumers and to the safety and soundness of financial services institutions, end of quote. As background, New York's BIT license regime, adopted in 2015, established a licensing requirement for all financial intermediaries who engage in a virtual currency business activity from New York or to a New York resident. There are more details on the article version of this vlog at bridgingtheweek.com. Check it out. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week at, of course, www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao, and enjoy the Olympics.